The Executor's Guide to Fraud Claims. Executor fraud occurs when an executor of a will uses deceit to misappropriate estate assets for themselves or for someone else who's not entitled to them. Claims for executor fraud can have serious consequences, including personal liability for the executor. What is executor fraud? Fraud occurs when the perpetrator unlawfully takes money, assets, or some other benefit. When the perpetrator is the executor of a will, the deceptive activity can be called executor fraud. Examples of ways that an executor could commit fraud against the estate and its beneficiaries include 1. Misappropriating funds or other assets. 2. Withholding inheritances. 3. Lying about estate assets. 4. Hiding or omitting estate assets. 5. Failing to notify a beneficiary of their rights. 6. Underpaying a beneficiary what they're entitled to. 7. Falsifying liabilities. 8. Charging inflated or extra fees. Or 9. Selling assets at below market value to a friend or someone else for some benefit. How does an executor account to beneficiaries? In California, the executor of a will can also be called a personal representative. Personal representatives are generally required to file an accounting covering the transactions that have been conducted during the administration of the estate with the probate court. However, if all of the distributees, the beneficiaries, the heirs, sign a written waiver of account, the executor then doesn't have to file an accounting. If the executor has to file an accounting, only upon completion of the administration will they file that accounting. The accounting requires specificity, and any personal representative should maintain records to substantiate the transactions that have occurred. What's supposed to be in a probate accounting? A final probate accounting must include a financial statement and report of administration that contains all of the information required by the California Probate Code. The California Probate Code specifically requires that all accountings filed with the court include a summary of the following information. 1. The estate property in the initial inventory. 2. The value of any assets received during the accounting period. 3. Net business income and loss. 4. Sales gains and losses. 5. The amount of disbursements, including distributions that have been made to beneficiaries. How often does an executor need to account? Generally, an executor needs only to file a final accounting and petition for an order for final distribution when the estate is in a position to be closed. A personal representative must also account whenever a court orders them to. Under the California Probate Code, the probate court has the authority to order an accounting at any time, either on its own motion or on petition of any interested person. The court is required to order an accounting if an interested person asks for one and it's been more than 1 year since the last accounting was filed, or if no previous accounting has been made more than 1 year after issuance of the letters of administration to the personal representative. What do I do if I'm accused of executor fraud? If you're accused of executor fraud, it's important that you take action to defend yourself. The problem isn't just going to go away on its own. If a beneficiary pursues an action against you for fraud, you could be removed as executor or even face personal liability, which means money out of your own pocket. And if you don't defend the action at all, then someone could get a default judgment against you, forcing you to pay even if the charges are meritless. Given everything at stake, you should consult with an experienced probate litigation lawyer as soon as you start to suspect that a claim might be instigated against you. That probate litigation attorney can help defend you against a charge of fraud or any other executor misconduct, and hopefully help protect you from personal liability. Is there a statute of limitations on executor fraud? The statute of limitations on lawsuits based on executor fraud is 3 years. Statutes of limitations are simply deadlines for when a plaintiff can pursue a claim and file it with the court. All of these deadlines are set by state law, so the amount of time that you have to file your case will depend based on your state. In a lawsuit to recover money damages from you for executor fraud, in California the statute is 3 years. However, this may not apply to a beneficiary filing for your removal as executor in probate court. Can an executor be sued for fraud? Yes, an executor can be sued for fraud, just like anyone else. Suppose an executor commits fraud against an estate. In that case, the people who suffered the loss because of the fraud can initiate a lawsuit against the executor to recover their losses, as well as any other relevant causes of action. Additionally, an executor can be removed as personal representative of the estate for having committed that fraud. The probate code also allows for a personal representative to be removed if they've wasted, embezzled, mismanaged, or committed a fraud on the estate, or if they're about to do so. When should I contact a probate litigation lawyer? If you've been accused of executor fraud, or you suspect that someone might be anticipating filing charges, you should contact a probate lawyer immediately. An experienced probate litigation lawyer can review your situation and determine the best defenses to any claims of misconduct that might be levied against you. You'll be much better served to retain a probate litigation lawyer than to attempt to engage opposing counsel on your own. Have questions? At RMO, we protect people like you every day. Give us a call, shoot us an email. We're always happy to help. The consultation's always free. Thanks for watching.